An international law expert says President Marcos should clarify the country's position in the dispute over Sabah.
This comes on the heels of an arbitral ruling favoring heirs of the late Sultan of Sulu in a $15 billion deal case. Speaking to News 5, Attorney Harry Roque said there should be a clarification from the palace on whether the Philippine government will assert its claim over Sabah or whether the case is merely a property claim of the Sultanate of Sulu. Roque believes the Philippines now has a stronger claim for sovereignty over Sabah, with the arbitral decision favoring Sultan Jamalul Kiram's descendants.
Meanwhile, other sultanates of Sulu are appealing for reconsideration over the arbitral ruling. They say it must not be limited just to the heirs of Kiram. Sultan and Dr. Ibrahim Bajin Shakirullah II told One News the chiefs that the ruling should also include the sultanates of Shakirullah and Alimuddin.
The Sultan who was the beneficiary of the North Borneo trophy was Sultan Salahuddin Karamat. And the Sultan Salahuddin Karamat is 7 generations ahead of Kiram, ahead of Bajin, ahead of Denalabirin. Does not include only the Kiram family or the heirs. There are also the other families of the Sultanate.
To share more of his insights on the matter, we have with us on the show international law expert Attorney Harry Roque is joining us live via Zoom. Attorney Roque, welcome to the big story.
Yes, good evening, Robbie. Good evening, Gretchen. And good evening, Philippines.
Hey, Attorney Roque, before we get to the question of sovereignty, maybe as a lawyer you could explain to us first the nature of this case. Is this essentially a private case?
Well, as it is, because it is an arbitral decision filed by the descendants of the Sultanate of Sulu and pursuant to an arbitration clause, it is a private case. The problem, though, is that the Sultanate of Sulu had already assigned all the rights over Sabah to the Philippine government. And that is why the Sabah issue has become a Philippine issue and not just a private matter for the Sultanate of Sulu. Don't get me wrong. I think the Sultanate of Sulu should be satisfied, should be paid their proprietary rights. They leased the land. The lease payments were withheld in 2013, and they should be compensated for all the property rights that the Malaysians benefited from Sabah. No? But at the same time, do not forget that this is a sovereignty issue because precisely of the assignment made during the time of President Macapagal, no? Where the Sultanate, in very clear words, assigned all the rights to Sabah to the Philippine government.
Okay, then let's get to that point now. Implications for the Philippine government, how should they handle it?
Well, that's why I said the President should clarify now whether or not we will merely allow the Sultanate of Sulu to have their proprietary rights satisfied, in which case we should support the arbitration, or whether or not we should set aside the issue of proprietary rights and say that this is without prejudice to the issue of sovereignty. But in any case, the decision bolsters the claim of the Philippines precisely because the arbitral ruling said that because there is a breach on the part of Malaysia and its predecessor in interest to continue paying the rent, then the contract had ceased to have legal validity and the parties must be restored to the status quo ante, meaning it must be transferred back to the Sultanate of Sulu, it must be transferred back to the Philippines.
Malaysia has already said that they won't budge over this arbitral decision. How much teeth does this actually have, and who will be enforcing the decision?
Well, comparing this with the West Philippine Sea arbitration, no? The advantage of this claim being a private claim is that they can rely on what is known as the Mirror Convention, whereby all signatory countries to that convention agree to enforce arbitral decisions as if they are final and executory decisions of their domestic courts. There's a temporary setback because the French court said it cannot be enforced in France, but of course, that does not apply to all the 162 countries which are signatories to the New York Convention.
Could you explain that again, just a basic thing, because everybody's been trying to wrap their heads around this when the first news broke that a bailiff in Luxembourg had served an order for this, and it was phrased in news as basically serving a seizure order. What is it essentially? How do we get a grasp of what actually happened in Luxembourg? What does it actually illustrate by way of enforcement?
Well, in 1878, when the Sultanate of Sulu entered into a contract of pajak with Overbend and Dent, the legitimate representatives of the British government in Malaysia then, they entered into a contract of lease where in exchange of the transfer of sovereignty and possession over Sabah, they will be paid 500 Mexican dollars per year. They defaulted on that obligation, and because of the default, the heirs now invoke the arbitration clause, which basically is asking or asks the arbitration tribunal to rule that, number one, Malaysia is in default, and as a consequence, they should not just be made to pay for the rent, but they should be made to pay for all the foregone income that the Sultanate of Sulu did not receive as a result of their breach. And that is why the amount reached 15 billion, because in modern international law, compensation for property taken by foreign governments will include not only the physical value of the assets, but the foregone income as well, which is referred to in international law as lucrum cessans. And that is why the amount is 15 billion. It's not just the rental payments that were paid, but all the income that Malaysia deprived the Sultanate of Sulu as a result of the failure to pay the rental payments.
Attorney Harry, one last question. It's messy enough trying to anticipate what the implication might be if it is raised as a matter of sovereignty between Malaysia and the Philippines, for that matter, geopolitical considerations across ASEAN. It's messy enough without considering the mess at ground level, particularly with families, the different sultanates. Now other sultanates and other descendants of sultanates are claiming that, uy, kami rin, not just the Kirams. How complicated and how much of a spanner does that throw in this entire case?
Well, it's not complicated at all. The title of the Philippines is derived from the assignment made by the Sultanate of Sulu, and the title in turn of the Sultanate of Sulu is pursuant to a 1700 Treaty of Cession, whereby the Sultanate of Brunei ceded to the Sultanate of Sulu half of what we know today as Sabah. Take note that the other half continues to remain under the ownership of the Sultanate of Brunei, but the heirs of the Sultanate of Brunei have not been enforcing their claim, unlike the Sultanate of Sulu. Now, as to who are the descendants of the Sultanate of Sulu, you see the parties in the arbitration relied on what is known as the Makaski decision, which is a decision of a UK English court in Malaysia, where after the last male heir of the Sultanate of Sulu died, the heirs went to court to adjudicate who amongst themselves should be recognized as descendants of the Sultanate of Sulu. So these are now the 8 descendants that are parties to the case. And their standing is because they have a valid English court decision recognizing them as the lawful descendants of the Sultanate of Sulu. There's nothing complicated about it. Although I have to admit, this will cause nightmares for diplomats, but I think inevitably there will be a diplomatic solution.
Okay, maraming salamat po, Attorney Harry Roque.